All right, well, I guess I didn't scare all of you off because I see some faces from the first session. First of all, this nice gentleman here has some extra copies of the handouts for this session. If anyone doesn't have one, can you raise your hand so that we can get some of them? I might not have quite enough. You can talk to Georgia about that. We got started at the first session, and I had 8, and I was very scared, so it's nice to see all of you here. Oh, good gracious. As indicated by Steve, my name is Cheryl Wilke, and this is what I do for a living. I am a labor and employment lawyer. I do litigation and counseling. The majority of my clients are car dealers, car dealerships, finance companies. I do some construction, and I also, strangely enough, have a bunch of dairy farms, which is another long story. I am the partner in charge of the Fort Lauderdale office, which means I have management, hiring, and firing responsibility within my own office. And as those of you sitting here know who also have that responsibility, it is remarkably like running a daycare center. Keeping in mind that don't like kids, don't have any kids, didn't want any kids, and now I am running a daycare center. And if you think your employees are fun, you should see when you've got 37 attorneys who all think that they should have a different desk and their secretary's mean to them and they want different pens. So it is, I understand the challenges that you face in hiring and firing and retaining the best, not just as an attorney who counsels people, but as someone who is responsible for a relatively large office. So my job today is to help you with the fuzzy stuff. What do I mean fuzzy stuff? My first presentation was about what we call hard law, ADA, FMLA, EEOC stuff, all those little alphabets, workers' comp, the stuff that you guys, that have statutes, that have rules, that have cases and litigation, and that you understand. What this is a nuts and bolts presentation about making sure that you do the right things, because here's how this works. There is no such thing as a good employee who becomes a good plaintiff, okay? It doesn't work that way. So your worst employees are the ones who are going to sue you. Now, if they're bad, miserable, terrible employees, they are 10 times worse as plaintiffs. Why? Because they have an attorney who will do whatever they say, no matter how silly it is. So what is the best way to keep out of employment litigation? The cost, the grief, the hardship, the publicity? The best way to prevent that is to hire the right people to start with, and that's what I'm going to work on with you guys today. Let's start with the hiring process. I hear this all the time. Well, they interviewed really well. If I haven't heard that 85 times, here is the rule about interviews. Everybody lies. They lie. Why? And this is my other favorite. Well, I asked them why they left their last job, and they told me it was because they were looking for other opportunities. Nonsense. In this economy, nobody leaves a good job. Nobody leaves a good job. So either their employer was a jerk, which means they made a bad decision, or they were a jerk, and now they want to be your jerk. Okay? I don't know how to make it any clearer, but here's how this works. The interview process is nothing more than prom night. It is when they wear their best clothes and they're on their best behavior and they tell your parents you're going to have them back by 10 and they do all the things that they're going to do, and then they walk out that door with your 16-year-old daughter and everything falls apart. Okay? So the interview is prom. Okay? It is the best this person is ever going to be. So if they do not interview well, my guess is that's probably a pretty good sign, because remember, this is the prom. It doesn't get any better than this. Here is my recommendation. I believe that the hiring process starts with how you post your job. Post in the right places. Okay? Use of vocational college placement and technical schools to reduce your recruiting costs. I can't tell you how many good car dealers like you do not use the resources at your community college and your vocational and technical school. These schools are pushing out these extremely young, bright marketing majors, people who have accounting degrees, people who have sales degrees. They are looking for jobs. You don't have to pay the vocational or technical school to get you these great workers. They will simply show up at your doorstep and you have your choice. I can tell you that these, I want to say kids, and that's not really fair because lots of people are going back to school these days for various reasons, but one of your greatest resources, areas that you can tap into, sources to get these great employees, is really through vocational, technical, and junior colleges. They are pushing out marketing majors like there's no tomorrow. Many of them are delighted to have a job in sales to get started. Now, I'm not telling you that these are necessarily going to be your lifetime employees, that you're going to have them forever, but I'll tell you that they will be aggressive, smart, willing to learn, and generally extremely ambitious. Understanding the difference between posting a job and posting a career. Well, what's the difference? Okay. If you post a career, meaning this is an opportunity to grow into a position, you will get better applicants than, I'm seeking a salesperson to work 60 hours a week, da-da-da-da-da-da-da-da. That's a job. That's a stint. You are going to find people who are looking for stints. When you post a job, and I don't care if it's on Monster.com, on your local, through the NIADA's website, whatever it is, if you're looking for a long-time employee, post for a long-time employee. Make sure that it's clear that this is a career, not a job. If it's a job you're looking for, say it's a job. But one of the biggest mistakes people have is, well, I hired this person and I trained them and I put all this money into them and now they're gone. Well, yeah, because they don't see a career there. So part of your job, part of the tough part, because most of you are owners and it's tough to always, you're not, obviously not going to share ownership, but is finding a way to allow people to merge into a career instead of simply a job. You're standing up. Am I doing something terribly wrong, Steve? No. Okay. Okay. Is less more in a job posting? Is less more? This is one of the tough things. I will tell you that a lot of employers make these big, long job postings that list everything in the world. You're going to have this benefit, and you're going to do this, and we're going to offer you this, and this is, okay, that is not a job posting. That is a job offer. And it becomes a contract. Because if they accept that job and you've promised them the moon and the stars and the blue, green, purple, that's what they're going to expect. Here is my recommendation for job postings. Keep it simple. Keep it objective. Make sure that your postings are not generic. Looking for a salesperson who's aggressive, who wants to work, who wants to be in a leadership. No, make sure that it's very tailored. What is unique about your business? What is unique? Find out what is unique and sell that to them. Because what are you doing? If you are looking for people, then you are trying to sell yourselves. We have a unique environment at X location. We have access to these kinds of customers. We're looking for salespeople who are interested in integrating into that environment. Sell yourselves. Be unique. Don't give them a long story about how you're going to give them health insurance and a 401k and you're going to match and you're going to do this, because someday may come where you can't do that. And they're going to say that you broke the employment agreement that they had. The posting is important. Less is more. Okay? Use of the internet. The Monster and Monster.com. Okay? The pros. There are pros. Ease of access. Cost. Very cost effective. Your postings are instant. You're not waiting for the next paper to come out or the next newsletter or whatever it is. It's instant. Great. Instant's good. We like fast. Wide range of territories and job areas. You can go anywhere. The internet goes anywhere. I went hiking in Machu Picchu, Peru, and my BlackBerry worked just fine. Doesn't work fine in Beverly Hills, California, where it doesn't work at all, but Machu Picchu, Peru, no problem. Had internet access the whole time. Okay? No obligation to interview every candidate. It is the ultimate screening device. Use it for that. You are under no obligation under any state law or federal law to interview every applicant. Well, I have to interview them. Why? No, this is your rodeo. You are not required to interview any. Use it as a screening process. Here are the cons. For those of you who have ever participated in online dating, you will know that people lie. They're 6'2", they weigh 180 pounds, they have blue eyes and dark hair, and they've never been married, and they have no kids, and they make $300,000 a year. It's a lie, okay? Job postings are the same way. If someone responds on Monster.com, they lie. It's way too much information, and it's too easy to put false information on the internet because it's not necessarily verifiable. So a lot of times it wastes your time because people say, I have $400,000 in portable business, I'm going to be there by Thursday, my job with my current employer is all roses and sunshine, I don't have a non-compete, I don't have a territory restriction. It's a lie! So do not take everything on Monster.com as gospel. Think of it as a dating site. It's about as accurate as Match.com, okay? Garbage in, garbage out. If you are posting jobs on Monster.com that do not accurately reflect what you're looking for, you are going to get garbage responses. If you need to get with or some other employment lawyer just for 10 minutes to help you do the posting and do it right, there is tremendous value in that. Okay. Predators are looking for claims. Okay. I had this happen recently at one of my favorite dealerships. A gentleman had a condition called deep vein thrombosis, which means he had swollen legs and he had issues. And he put on Monster.com that he was an experienced salesperson and that he had worked in these areas and that he had experience in these types of vehicles in particular. This was for a flag dealership. And that he, but that he needed to be able to wear slippers because he could not wear regular shoes because of his condition. So my employer calls me and says, well, what should I do? Well, I'm sorry, let me back up. They don't call me then. That's when they should have called me. So, no, they missed that part, sorry. So they bring him in for an interview. And for reasons that have nothing to do with the deep vein thrombosis, primarily that his personal hygiene was just ridiculously bad, they chose not to hire him. He then filed suit, saying that they violated the Americans with Disabilities Act by not hiring him because of his disability, because he met all of the other job qualifications, but when they met him, even though he had disclosed he needed to wear slippers, he wasn't hired. There are lots of predators out there. They use these websites on purpose. That's what happens. Here's the deal. If it doesn't feel right, do not interview them. I hate to be so cynical, but it is not worth it to you. Okay. Monster.com or any other kind of web posting requires a two-step process. One is to get the information through the posting, ascertain how much of it is a lie. So first you got to go to the dating site and you've got to hear all the lies, and then you got to bring them in for the prom. Okay. And you bring them in for the interview, and you've got this two-step process now as to whether or not to hire somebody. That's where you get this predator mentality. So there are some detriments in my mind to using blanket websites and blanket job postings. Okay? Your competitors can see what you're looking for and price themselves accordingly. And if you don't think you guys are doing that, you are also lying, because I know you do it. Well, so-and-so's Maroney's looking for a salesperson, and they're willing to pay X, and they're looking for 6 salespeople. Their business must be really great. We're going to have to go ahead and do X to make sure that they don't get those sales. It happens all the time. How much of your business confidential information do you really want your competitors to be able to see? Because remember, once it's on the internet, everybody can see it. Not just job applicants, but your competitors. If you don't care, I don't care. I'm just telling you that I know that flag dealerships will look to see what you guys are hiring. Why? Because they want to know. Okay. Key rules for hiring right. Use one application process only. I don't care if you require that they fill out an application on the internet. I don't care if you have a paper that they're required to mail in. I don't care if they're required to fax it. I don't care if you require them to bring it in person. One process only. That prevents discrimination claims. Okay? So if you require people to fill out an application on the internet, great. If you require that they fill out a paper application, great. Don't mix and match. Have a process, stick with it. Where claims come up, is when somebody says, well, they didn't see me because I filled out an application online, and then when they saw that I was blue, green, purple, gay, straight, black, green, whatever, they didn't hire me. But the guy who brought his application in, he was white and they hired him. That's where those claims come in. And here's the deal. Here's the secret that lawyers know. It's all discoverable. Meaning that when you get that subpoena that says, give me every application that's been filed in the last 2 years for your prospective employees, you have no choice. It is not confidential. Not now, not ever. Okay. Ensure that none of your application materials make reference to protected classifications unless required by the job. For example, if you're going to have a mechanic, mechanics must be the age of 18 in order to work certain you can say, must be 18. If they're required to have a valid driver's license, most states it's 16 years old, you can say, must have a valid driver's license, be 16 years old and have a valid driver's license. Otherwise, do not make any reference to blue, green, purple, men, women, whatever. Use no classifications. Do not say, salesmen will be expected to work salespeople. It implies that you're only hiring men. Generic is better. Notify prospective employees if they are subject to drug testing, background checks, and credit history disclosures as part of the application process. Why do you do this? Because it weeds out all the garbage. If you tell these people when they fill out the application, if you fill out this application and we select you for an interview, you will be required, hi, get all kinds, come on in. If you fill out this application, you will be subject to a drug test, a background check, and a criminal check for those where it's allowed, and we'll talk about that in a second. You will get a lot of people who you don't want who will simply leave you alone. This is one of the best screening processes you can have on your application. Do not apply here, do not submit this application if you've got bad credit, if you know, really bad credit, sorry. You're a convicted felon, you know, or you use drugs on a regular basis, because we're going to test and we're going to find out. And most people do not want that to be public. It is a great, use your application process to screen out the bad people who are going to be bad plaintiffs. Because by the time they come in for the interview, if you don't already know that and you get your heart set on this perfect person and find out that he's got 6 felony convictions for domestic assault, you've wasted a lot of time, a lot of effort, and now you've got problems. More rules for right hiring. Designate 2 people to conduct interviews for a particular person. I suggest that you always have a business person do an interview and a job-specific person do an interview. Why? Because the job-specific person interview is looking for certain traits and certain attributes to do the job, whether it's a mechanic or a salesperson, and the business person is looking on the HR side or management side, corporate management side, is really looking for kind of to make sure that all the other requirements are there. Do they have the right licenses? Are they, you know, well-behaved? Do they have X, Y, and Z? It is never a good idea to only have one person do interviews, no matter how good that person is, unless it's the owner, like you know, if you guys are owners and you know what you want, you know what you want. But I really suggest even then, you should really have someone take why not get a second opinion? And I will tell you that if you have women who work for you and you're hiring this guy who appears to be too good to be true, let the woman interview him, because I guarantee you she'll be able to tell you exactly what's wrong with this guy. Because we know, we've dated him, we know, we've seen this movie. Okay? We know exactly. If they come in and they are too good to be true, they are, and there are problems, and we can tell you what they are because we know. So don't hesitate to use your own resources. Instinct is a very good judge. Again, if it doesn't feel right, it probably isn't. How many of you can tell that you took a quote unquote took a chance on somebody? Listen, they had all these great things in this paragraph, but you know, there was a couple things over here, and, you know, I thought for sure we could train those out of him, and once he got to be part of the family, it was all going to be fine. How many people have hired those people and have had nightmares down the road? Yes, it happens. This is how to prevent those nightmares. Get a second opinion. Have somebody else interview them. Never make any promises as to the length of the process of the application, the method of communication, or the salary at the initial interview. Never, 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 never. Okay? Never tell them we're going to make our decision by Friday. You can always say we plan on making our decision soon. But the more of those promises you make, the more problems that you have with those predators that we talked about, people who say, well, they didn't tell me on Friday, but the 2 white people, they told them on Friday they were getting hired. Predators use that information, so do not make those promises. I also suggest that you do not make promises regarding salary at the time of the initial interview, except for commission salespeople, because I believe that you've got pay plans. Those are probably going to be pretty standard. It's probably not no harm, no foul if you want to do that. If you've got an unusual pay structure, I wouldn't do that, but if you're using a standard commission schedule, a pay plan of some kind that deals with all the stuff that you guys, PACs and all that stuff that you guys deal with, it's probably okay.
What if the question is specifically asked?
I'm sorry?
What if salary is asked by the applicant?
Then I would say that, you know, that we're evaluating all the applicants and that the position is X. Let's say the position is a comptroller. The position is a comptroller. We are thinking of a salary range, but the actual salary offered will be based on your experience and your qualifications. Period. If we choose to make you an offer, it will be specific to you. You're not tying yourself in, you're letting them know it's about their experience, their education, and their qualifications. You're not getting locked in, you're not giving them a range. Ranges are scary. Because if you're a prospective employee and you hear that the range is 50 to 70, you want 70! It's not 50 to 70, it's 70! That's what their expectation is going to be, because everybody thinks that no matter what the range is, they're at the top. Why? Because everybody's special. Back to everybody lies. So that's, you know, those are the concerns. Sir? Absolutely.
If you put that in your posting, are you required to then carry on with it?
You need to, you know, for the most part, I don't put that in the posting. I don't think that that's necessarily good. I put it in the application. Now, if you only have, that falls in the category of too much information in the posting. I put it in the application and I boldface it. It's the first paragraph after your name. But I do not put it in the posting. I think that that's bad business, and you do not want to create something that you're forced or compelled to do, because then if you do trust somebody and you don't test somebody else and it turns out that one of them's Hispanic and one isn't, you've just bought yourself a problem. Selective enforcement is always a problem. So if you don't promise to do something, you can't selectively enforce it. Okay. All right. The quagmire of criminal background checks. May 1st, 2012, actually this was April 30th, but it didn't get posted until May 1st. The EEOC passed new rules regarding the use of criminal background checks by employers. Not credit background checks, just criminal background checks. The background checks cannot result in discrimination based on race or national origin, even if the race is neutral on its face. So let's say that you have an application and you're looking for mechanics, and you put out an application, you know, you put out a posting and then you get a bunch of applications. You tell them that they're going to have criminal checks. Several of them apply, and it just so happens that all of the people who have poor criminal checks, felonies, convictions, DUIs, whatever, happen to be black, or happen to be blue or green or purple. It makes no difference. The EEOC is concerned that certain diverse classifications are getting fewer opportunities because of their backgrounds. Now, a lot of people can argue with that, and I'm not saying everything that the EEOC does makes sense to me, because this really doesn't. I think that employers should have the right to make decisions separate from race or gender or any other protected classification as to whether or not they want a convicted felon on their job site. The EEOC disagrees with me. And they now have limited to whom criminal background checks can be imposed. You can have background checks on anybody who touches in your industry, keys, checks, or cash. If they've got check signing authority, or they're handling people's checks, or they're handling cash, or they're handling keys, you can do background checks, criminal background checks. Okay, credit checks are less restrictive. Employers are allowed to consider prior bankruptcies as part of the hiring process, except if you're in New York, Vermont, and Connecticut. In those three states alone, which are part of the Second Circuit Court of Appeals, they have a case. It's the only 3 states in the country that say that you cannot use a bankruptcy to prevent as a grounds for not hiring somebody. Now, no employer in any state at any time can use a filed bankruptcy, regardless of when it is, to fire an employee. Well, what does that mean? You've had an employee for 7 years. You find out through the grapevine that he's had some financial troubles. You check online, because nothing is private anymore. You determine that 2 years previously he had filed a bankruptcy, and the bankruptcy has subsequently been discharged. You cannot fire him because of that. No one can fire an active employee because of a pending bankruptcy. And they say, well, why? Why does that make sense? Because here's the rule. Rob knows this bankruptcy stuff much better than I do, but bankruptcy is supposed to be a fresh start. It's supposed to give people the opportunity to get rid of their debts and to have a fresh start. They shouldn't be, if they're trying to keep their job and maintain and trying to do the right thing, they should not be penalized for exercising their legal rights to file bankruptcy by being fired. That's the basis. So it does make some sense when you put it in that context, but be very careful. You cannot fire an active employee because they've had a bankruptcy, either if they had the bankruptcy yesterday or they had it 20 years ago. If they're already your employee, you cannot use that. Again, use the credit checks. I would use credit checks fairly cautiously. I'm not sure that I would use it for the people who you are concerned about having access to your stuff, whether that stuff is cars or money or accounts or your customers' stuff, but it's really kind of a stuff concept. Do they have access to your stuff? Do they have access to customer stuff? Are you concerned that they are in financial straits that would tempt them to take stuff? You know, there's just, it's, yes, sir.
Would you say that on your application, you state that a credit check that could be taken on them, that you'd be covered as an employer?
Yes. Here's the great thing about an application. You can say pretty much anything you want as long as it's not based on sex, race, gender, any of the religion, any of the protected classifications. You can say, we reserve the right to drug test, credit check, criminal check. You can put it on. You're not saying you have to, but you say we reserve the right to before you're hired. You can say that about just about anything. Now, you can't, unless there's a physical demand for their job, you can't normally ask them to take a physical demands test. They don't have to be able to run around the block or do 50 pull-ups or any of that stuff unless it's a requirement of the job. Yes, sir, back there.
If you already have employees that have access to cash checks and you've already distributed keys and you want to tighten that down, can you then do background checks?
That is a great question. The gentleman asked whether or not if you have active employees, can you retroactively require background and criminal checks? The answer is you can ask, but you can't fire them if they say no.
So just don't let them know that.
Okay. Lawyer hat, business hat. Okay. Lawyer hat. Of course you're going to tell, no. The reality is you cannot make it a condition of their current employment unless you're going to give them a raise or transfer them to a different department. So for example, if someone is going to be moved from a salesperson to a manager's job, even though they've been an employee, you can make credit checks, criminal checks, and drug tests a condition of a new position within the same company. What you can't do is say, you're a salesperson now, you were a salesperson 6 years ago, to keep your job as a salesperson, you have to do X. That you cannot do. But if you are transferring their position or, you know, something along those lines, you can. You cannot fire them if they refuse. Unless they're being transferred to another position, another department, etc. Okay. Do you guys know what? Oh, I'm sorry, ma'am.
Okay. So what if you start a employee handbook and you change something like that? Can you have everybody sign off on it?
You can, but it's exactly the same question. So new hires it's a job requirement that they be subject to drug testing, background checks, but existing employees, even if they sign the handbook, it cannot be a new condition of employment, so you can ask nice, and if they say yes, great, but if they say no, you can't use it to fire them, even using it through a handbook. Okay. Any fiduciary employees, you guys know what that means. Anybody who's got check signing authority, anybody who's got power, anybody who you have to bond, anybody like that can always be checked. Wow. Does that mean my time is up? I don't know what that means. Okay. Proper questions on every application. Can you perform the essential functions of your job? This is so you don't get into ADA problems, okay? Never use what you see to solicit information beyond the question above, okay? Why is that important? So let's say somebody comes in and they are in a wheelchair. and they say that they can perform the essential functions of the job. And the essential functions of the job as a comptroller is to be able to issue checks, use whatever computer program you have, be able to figure out all those crazy numbers that you guys have to deal with. Rob and I went to law school because there was no math, so this is why we do what we do. Okay. Can you say, well, do you think you can do that job if you're in the wheelchair? Just because you can see it doesn't mean you could ask about it. In fact, that's one of the biggest mistakes that employers make. You cannot inquire about something after you have solicited the information. Here's the only question you can ask. Are you able, here's the essential functions of this job. Are you able to do them, yes or no? Period. End of conversation. And that's the way it should be. Okay. You cannot ask about prior workers' compensation cases as part of the hiring process. Now, here is the magic to this. Almost every state now, you can go onto the state's website and find out how many workers' compensation cases that they've had and how many different employers they've sued for how many different things. And you know what? They don't ever need to know that that was part of the consideration. Okay? The reality is, it used to be you could never ask about comp cases, you couldn't use. You know what? It's all public record now. That's the way it goes. The reality is that people need to know that. After a job is offered, an employee requests an accommodation. The interactive process is required. Back to the person in a wheelchair. She says she's able to do the essential functions of the job as a comptroller. You say, great, no problem, we'd love to hire you. She then says, I need this accommodation, I need to have a ramp, and I need to have access to this elevator instead of the regular elevator. You say, great, we talk about it, see if you can work it out. That's the interactive process. It does not have to be litigious, it just has to be interactive. What you can't say is, absolutely not. That's the wrong answer, and it should be the wrong answer. The right answer is discuss it and figure it out, and that's what the courts require. How do you keep the best? Okay, we've gone through this application process. We have a nice, clear, succinct job posting. We have an application that weeds out nonsense and bad people, hopefully. So we've been, we've been on Match.com, we've been to the prom. Now we want to keep the date and make marriage work, okay? Because that's really, with some of your employees, that's really what it is. Have an employee handbook. This nice lady is absolutely right. Have an employee handbook which applies equally to everyone. Ensure your promotion and salary process is fair and based on merit, not on who you know. Well, we're going to promote Doug because his father's uncle is the chairperson of the whatever. No, those days are over, and I don't care what state you're in. That stuff is done. Hire and promote people based on merit. What do they do? How do they do it? Do they do it well? Do they move forward your business? Not on this is so-and-so's nephew and we're going to give him a job because we're going to get X. Okay? Please tell me those days are almost over. I know it's tough. And listen, we have law clerks. Rob and I have law clerks in our offices. I'm not telling you that we don't hire the sons and daughters of our clients to be law clerks, but that's a 3-month stint, and that's a favor, and they're not taking a job away from anybody else. Okay? Use annual reviews consistently. Here's my favorite. Well, he was doing a bad job, so I did a review and he failed. Really? Honestly? Well, but he hadn't had a review for a long time and he was doing a bad job, so I did a review and he failed it, so I want to fire him, Cheryl. Can I fire him? No! No! Who else got reviewed? Well, nobody. He was the only one messing up. No! A review is not a disciplinary process. It is an evaluation process. Do your reviews either the same time every year for everybody or on anniversary dates. I don't care, but do them. Do them well. Do them consistently and be honest. Keep your benefits, your vacation, your paid time off based on a yearly schedule instead of date of hire. I just do that because I think it's more convenient to you. You know, you got to prorate it for the first year, but then after that, you're able to budget. For those of you who have 15, 20, 15, 12 employees, you are able to budget. You know that each year you've got from calendar year to calendar, January 1st to December 31st, you have 15 employees who have 4 PTO days. That's 45 days. You can budget that. If you've got a whole bunch of people who have different anniversary dates and their paid time off is based and their vacation is based on the date, it is almost impossible to budget for that. Allow employees to participate in their own future. Careers versus jobs. Okay? Here are the jobs that are going to be opening. Please let me know if any of you are interested in any of these positions. Hire and promote from within. Let your people be part of the improvement and the process of your growing business. When it just doesn't work out. There are two different ways it doesn't work out. It doesn't work out because of performance, and it doesn't work out because of personality. You call it whatever else you want, okay? Performance. Objective standards are always the best. You have to sell 15 cars this month or you're subject for termination. You have to sell 45 cars within a 3-month period. Whatever it is, objective standards are best because they're easy, they're clear, and the EEOC loves them. They will never, ever, ever get you for firing somebody who fails to meet an objective standard as long as you're consistent. Written goals and requirements with the employee's acknowledgement. So if you have a problem with performance, you say, sit down with the employee, here are your written objections, sign them. If they don't do it, you've got every right to terminate them. Provide a definite time for each goal. In the next 2 weeks, 2 months, 2 years, you have to do X. Make sure that the performance problems are addressed and that they are addressed on a time-specific basis, so they can't just be open-ended. Be clear that failure to meet the goals results in a separation. Okay. Personality intangibles. You can use performance improvement plans. These are like little mini contracts that say, we want you to stay here, we know you want to stay here, but you need to fix these things so that we can all work together. Your employee handbook is your best friend and can be your worst enemy. Okay. Had this situation come up. I missed 16 days and I got 4 points for that, but I was supposed to get a written warning at 8 days and nobody gave it to me, so you can't give me a written warning. The handbook says you have to give me a written at 8 and you didn't say anything to me until you suspended me with 16 and you lied. Ah, what a mess. Be careful that your handbook does not become your worst enemy. Always use written confirmations. Email's fine. Yes, I've read this. I agree that I will do this. Enforce policies consistent. Separate sooner than later when you know. You know! This is the date you're never going to get married to. Do not stay with him or her forever. It's not going to work. Sooner is better. It is always less painful, and it is always less expensive. Yes, sir?
When we, discipline an employee or whatever, we write them off, and, it says employee acknowledgement, and we've had employees not sign
Sure.
that.
That's okay. They do not have to agree. They must sign that they have received it. They have to acknowledge receipt. If they fail to acknowledge receipt, you can separate them. That's not the way it rolls. They don't have to acknowledge that they agree to it or that they think it's right or anything else. But they have to, the law allows you to require that they acknowledge receipt of it. So if they refuse that, they're gone. Whoop, I heard a lady's voice. Yeah, because, they have to acknowledge receiving it. There's no legal basis to refuse to say, someone handed me this. And if they do not do that, they're basically violating your policy. There's no reason to keep them. That's not the way it goes. You can, but I have to tell you, that's one of those things that I have in my handbook. They have to acknowledge receipt of any disciplinary reports.
We're at will state in New Mexico.
Oh, so are we in Florida. It means absolutely nothing these days, but keep going.
Oh, well.
No, go ahead.
Well, because, then you got the process of going back into, everybody wants to get paid because now they're fired, now they want to go and get compensation for nothing. So, that's the problem we have with the at will. People want to use unemployment.
Yeah, okay, quick on unemployment because I'm running out of time and I want to make sure I get through this. But here's the concept of unemployment. And this has always been an issue for especially my employers, my car dealers. Unemployment is payable even if someone is terminated for cause. Okay, I want to be very careful here about the difference between cause and the definition of misconduct. Okay, misconduct is a much higher standard. They stole something. They were sleeping and they allowed something, a safety violation. They yelled at a customer, stole something from a customer, something along those lines. I realize that in every state, the definition of cause and the definition of misconduct is going to be different, but in every single state, you must have misconduct in order not to pay unemployment compensation. Does that make sense to everybody? Everybody says, well, I fired him for cause, so I don't own unemployment. No. No, unemployment is payable unless there is misconduct, and that is true in every state. For example, in California, It is almost impossible. They can basically steal from the cash register, kidnap the boss's daughter, and steal the car, and that's not going to be misconduct in the state of California, okay? In states with I's and square states, Iowa, Illinois, that will be misconduct. Yes, ma'am?
You're absolutely right, and that's where a handbook comes in, between stealing cash, absenteeism. You have it written in your handbook, and that's.
Yeah, you have to be careful because you can't redefine misconduct in your handbook. You can't say this is misconduct and you won't get unemployment, because the only people who can decide whether or not it's misconduct is the Unemployment Commission. But what you're doing is right. You're putting them on notice and you're clarifying the point. Absolutely, ma'am. The process of termination. Everybody hates to fire people. I get that. I will tell you that 25 to 30% of the litigation cases that I get happen because we don't fire right. Not because they didn't do anything wrong, but because we don't fire right. Have all your approvals and documents ahead of time. You know you're going to fire somebody. Get the COBRA stuff. Get all the notices. Get everything. Get their last paycheck. Get whatever it is you had ahead of time. Have it with you, okay? Ensure there is one witness and one supervisor present. There must be a management person and a witness. I do not care if that witness is management or not. I just want a witness. Provide objective and concise documents and information. You are being fired because you violated company policy X. You are being fired because you failed to meet your sales quota for the month of June. Boom. Objective, concise. Do not be afraid of the silent moment. That moment when that little lady sits next to you and gets the big tears in her eyes, and having used this before, I know it is effective, and sit there and say, but. Do not rush in and start filling in that silent moment with other stuff. Well, you know, we feel really bad. We know you've got to. No! Do not be afraid of the silent moment. Let it go. Sit there quietly. It is expected that they will be angry. It is expected that they will be hurt. You cannot talk them out of that. Do not try. Concise. Do not apologize. I'm so sorry, but we have to. No. No. You're sorry because they screwed up? Really? No. Separate at the end of the day or the end of the week. For any security issues, be prepared. Unless absolutely necessary, do not do a walkout. I will tell you that most of my cases come up because people are embarrassed when they're walked out after they've been separated. Do not do that. Unless you've got security concerns that someone's going to, you know, throw a fit, turn over desks, throw up papers, be violent. Be professional. Terminate them at the end of the day. Let them collect their personal belongings and let them leave with their head held high. If you've got security issues, local sheriff's offices and police departments are thrilled to death to sit in your parking lot while you do a termination. All you have to do is ask. I have never once had anyone say no when I've had security issues when I'm the one who does the termination. Because I know it's tough to tell, but I'm the one who gets to be the bad guy all the time. You know, that's my job. Cheryl, you got to come in and fire so-and-so. Okay. And that's what I do. Because if it needs to be done, it needs to be done. All right. Unemployment, we talked a little bit about this. An employer, do not promise unemployment at the time of separation. Oh, it's okay, you're going to get unemployment. You do not know that. You cannot decide that. Only the state in which you're in decides that. Be cognizant of any confidentiality or related employment terms. Make sure that you remind them in their exit package. This is a reminder. You have a confidentiality and a non-compete. These will be enforced. Provide only neutral references regardless of the reason for termination. So-and-so was employed here between January 1st, 2010 and September 17th, 2011. They were employed as a commissioned salesperson. They've been separated, period. Neutral references only. Contest unemployment based on misconduct and not performance. We talked about that. All right, gentlemen in the back.
State of Florida, 99 out of 100 times that one interview takes place on the unemployment.
Yes.
Always means to be unemployed.
Correct. Florida is one of those states. Why is that? Because Florida does not have enough money to pay welfare to a lot of these people, so they put it through unemployment instead of allowing them to collect public assistance. Why is that? Because unemployment is funded by you guys. It's not state money. So if it's funded by you guys, they're happy to give away your money rather than have them applying for state aid. They'd much rather give away your money. Here is me. This is me. I do, as you can tell, I'm a complete and total geek. I love this. I love what I do. I love working for my car dealers. I have a relationship with NIADA. I will answer any of your questions for free. If I don't have to look it up and I don't have to write it down, you can call me anytime, send me an email. I work 24 hours a day. I'm a complete and total geek. This is what I do. So I am at your service. I want to make your jobs better. Yes, sir. Any questions, comments, concerns? I know I'm running out of time, but yes, sir.
Is there a way to have someone resign, mutually resign, opposed to being terminated?
There is no such thing. There is a resignation or there is a termination. There is no such thing as a mutual resignation. Either they've resigned or they've been terminated. I always give people the opportunity to resign.
In the event they agree with it?
They are entitled to unemployment by definition.